Good afternoon. This is Matthew Consolo, a partner at Secrest Wardle. I am broadcasting today from our office in Troy, Michigan. I am here to talk to you today about understanding indemnification issues. As you know, indemnification claims are a very important part of the claims process and one of the most important things to look for when handling a claim. Let's face it, indemnification is a pretty dry and boring topic, but this is an area of law that can turn your claim completely upside down if you don't get it right. It can also greatly affect managing and setting your reserves early on in files and determining the course of action to take throughout the litigation. It is definitely an area of law that you must know if you have to defend any claims involving contracts including construction, fire, premises liability, or simply general liability claims. Understanding indemnification is something that you must know in order to preserve and advance your careers and also pass audits when the second guessers come around and start asking questions. My job here today is to help you do your job and help you get it right early on in the case. Throughout this webinar, I'm going to provide you with some practical advice when dealing with these types of issues. Throughout this webinar, I will share some ideas on how to read and understand indemnification clauses, which can look difficult and daunting, but are really not that hard. The first thing you need to determine early in any case where a written contract is present is whether one party owes another party indemnification. To begin this process, you must obtain all of the contracts involved, whether that is a lease agreement, a construction contract, or even a purchase agreement, to see if there are any potential indemnification issues hanging over your claim like a black cloud. Always remember that indemnity is a two-way street and that it can be used as a shield or a sword depending on whether your insured and you ends up picking up the tab or if someone else is picking up your tab. So your job at the onset is to determine early on what contracts there are and to review them so you can properly set your reserves and set the best defense planning strategy that you can depending on the indemnification language. The next thing you must do is to forget everything you know about fault when evaluating indemnity claims. Instead of thinking about fault, you must focus on the language of the indemnification clause. The reason being, with just one exception that I will discuss later, is the contractual language of the indemnification clause is the only thing that matters. Fault does not. I understand that is hard to do because our minds in this industry are trained to find fault and the degree of fault. Almost all of our cases are decided by who was at fault, but when dealing with indemnification provisions, fault typically does not matter. For example, we dealt with a case where an individual drove a dump truck into a low bridge, killing the dump truck driver. As you can tell, this case involved several issues. One was a wrongful death claim out of the dump truck driver's estate. The second was a property damage claim for the damage done to the property. Everyone's initial reaction when seeing this claim was that it was clearly the dump truck driver's fault because it was an open and obvious danger that the dump truck driver drove into. Therefore, the initial reaction would be setting the reserves low and not paying on this case because it is not worth anything based on fault. This is exactly how we have been trained to think. Well, with one exception as to fault, we must delete the fault category in our claims-driven mind and strictly focus on the indemnification language because guess what? In this case, you are about to pick up a $1 million tab because your insured agreed to indemnify the contractor whose negligent driver drove into the open and obvious structure. My goal here is to help you avoid such bad surprises. Additionally, you have to understand that a party can contract away all of its liability, even if it is at fault, as long as the indemnification language is proper. Again, a party can contract away all of its liability, even if it is at fault, as long as the indemnification language supports that position. Put another way, a party can assume another party's liability, even if the other party is at fault, so long as the indemnification language supports the position. A party that is not at fault, did absolutely nothing wrong, may owe indemnification to the at-fault party based on the language of the indemnification provision. To reiterate, it's all about the language of the indemnification clause, and you must accept this. Indemnification is not a time to consider justice, fairness, equity, and who is right or who is wrong. Now, let's discuss how to read and understand an indemnification clause so you get it right early on and don't get surprised by your own dump truck scenario and end up picking up someone else's tab late in the game. Let's face it, all of us on this webinar have gotten pretty good at understanding insurance policies to determine coverage issues. If you can read and understand insurance policies, I promise that you can read, understand, and properly evaluate an indemnification clause. If you can read an insurance policy and determine coverage, you can use that same skill set and analyze an indemnification clause to determine who is picking up the tab early on. So let's start at the beginning and discuss who the indemnitor is and who the indemnity is. As in, the indemnitor agrees to indemnify indemnity from and against any and all liability, and so on. So is your insured the indemnitor or the indemnity? In simple terms, the indemnitor picks up the tab and indemnifies the other. The indemnity is the protected party even if they're at fault, with just that one exception that we will discuss later. Admittedly, this is a tough thing to get through our fault-driven minds, since the indemnity is really the screwer and the indemnitor is the screwee. But again, we have to keep fault out of the equation. Once we have the party straight in terms of the indemnity clause, then we have to read the clause and analyze what it covers, how encompassing it is, how it speaks to causation, and whether it speaks to covering the indemnity through their own negligence. It is simple if you read the clause like you do an endorsement in an insurance policy. Just like they say in the cases involving coverage issues, remember that every single word counts and every single phrase must be given its ordinary meaning so the intention of the parties is met. The law is clear, however. A party can be protected against its own negligence so long as the indemnification clause is clear and unequivocal. I am going to provide a few examples that track the evolution of the indemnification case law in Michigan. Let's start with the phrase, quote, from any cause whatsoever, end quote. As in, Party A will indemnify Party B from any and all accidents or losses arising from any cause whatsoever. About 35 years ago, our appellate courts decided a case called Clowen that held the words, quote, from any cause whatsoever, end quote, was clear enough to include the negligence of the party seeking indemnification. In Clowen, Party B was indemnified for its own negligence because the clause used the magic words, quote, from any cause whatsoever, end quote. However, as time went on, our clauses became more sophisticated and included more legalese. For example, they would say, quote, Party A will indemnify, quote, Party B from any and all accidents or losses from any cause whatsoever, but including losses or accidents partially caused by the negligence of Party A, end quote. The courts held that this was even better because it elaborated on the, quote, from any cause whatsoever language and expressly covered the negligence of Party A and the intentions of the parties. To reiterate, every word and phrase counts and must be given its ordinary, plain, everyday meaning. Following the cases I just discussed, there was not any significant appellate decisions interpreting indemnification clauses until approximately 2 years ago when our appellate courts issued an opinion on a contractual indemnification in a case called Miller Davis v. Ahrens Construction. Ahrens is spelled A-H-R-E-N-S. The major takeaway from this new case was that the importance of every single word in indemnification clause matters. In that case, the clause read, from any and all, and as you will see in a moment, the term all is the key word, accidents arising from any cause whatsoever. The single focus in this case was on the term all. The court found that the term all is all-encompassing and means everything. After several insurance companies expanded tens of thousands of dollars on defense costs, and after each party wrote 50-page briefs, our appellate court literally ruled all means all, and the intent of the parties was to protect the indemnity from its own negligence. I am puzzled that as the case law in this area has evolved, you would think everyone would use the same indemnification clauses that have been tested and tried in court. But that is not always the case, and someone always has to tweak them to say something that is untested, oftentimes leading to more litigation, appeals, or unfair settlements. Now, there are several different variations that permit a party to be protected from their own negligence. However, we would need much more than this 30-minute webinar to cover those in detail. I just want you to know that the major takeaway from this portion is, and in more general terms, to read and reread the indemnification clauses to determine if it applies to your insured, your loss, protect the party from being indemnified from their own negligence. If that language is clear and unambiguous, your insured will either be picking up the tab or will be having its tab picked up. Again, it's always important to make sure these determinations are done early in the process to help the game planning and litigation strategy. Now I want to change gears and discuss how to successfully tender the defense of your insured. Again, it is important to do this early in the process to minimize cost and attorney's fees. First, you will need to read the indemnification clause and look for the word defend. For instance, Party A will indemnify, hold harmless, and defend Party B against such claims. You can tender the defense without the word defend, but if the clause contains the word defend, your tender defense is much more strengthened. Next, look into what the insurance provision in the contract states. Part of this is going to be either in the indemnification provision or adjacent to it. You must be aware of these issues to help your tender defense strategy. The insurance provision in the contract may require that the insured must name your insured on their policy. Then your tender of defense is strengthened and, depending on the language, absolutely golden. Now, if your insured is named as just a certificate holder, then it likely will not help your position because a certificate holder is simply a party entitled to notice if the policy is canceled. However, remember, you can tender the defense even if your clause does not state defend and your insured is not named on the policy. It's just better if you have that language. Now, getting back to indemnification, you must also read the contract in terms of provisions stating attorney's fees or cost of defense, as in Party A will indemnify and defend Party B against any and all losses from any cause whatsoever, including costs and attorney's fees. The courts find this language is better because it will clearly demonstrate an intention of the parties that you will not only be indemnified, but that the costs and attorney's fees will be covered. At this point, if the other side ignores or denies the tender of defense, you must work with your attorney to file a cross-claim against the indemnitor. This will get the clock started because the law says once you tender the defense, the indemnitor is on the hook for cost and attorney's fees. Previously, I mentioned that there is only one area of indemnity law where fault was an issue. This relates to the statute that you now see before you, MCLS section 691.991. Basically, the statute says that in a contract involving the design, construction, alteration, repair, or maintenance of a building, including sidewalks and common areas, that Party A cannot receive indemnification from Party B if Party A is solely or 100% at fault. This statute applies in situations no matter what the indemnification provision states. In other words, even if the contract includes all the good language we discussed earlier, if the contract involves the construction or maintenance of a building, the sole issue is the fault of the indemnity. When I highlighted in yellow at the bottom of the statute is that if a party is solely negligent, the indemnification clause is against public policy and is void and unenforceable. The evolution of indemnification clauses flowing from this statute now include Party A will indemnify, hold harmless, and indemnify Party B from any and all accidents from any cause whatsoever, including if caused partially by fault of Party A, provided Party A is not found to be solely negligent in causing the loss. Here's the hook with this statute. You must focus on the terms sole negligence for the party that wants indemnification. The law says you have to consider the comparative negligence of the plaintiff and the other defendants to determine whether the party that wants indemnification is 100% at fault. Now, we all know plaintiff and or plaintiffs are typically guilty of comparative negligence to some degree. Let's go back to the dump truck accident I discussed earlier. If the jury awards just 1% of fault to plaintiff and the jury assesses Party A, which is the party wanting indemnification, with 99% negligence, then Party A will still get indemnification because they were not solely 100% at fault. As a practical matter, you rarely see a case where Party A is assessed with 100% fault and getting no indemnity. One of the reasons we rarely see this is because these are typically big cases that have numerous parties all pointing the finger at one another. However, given this statute, you need to assess liability and apportionment of fault as early as possible when trying to determine tender of defense issues. This typically occurs after the close of fact discovery. I hope this webinar has helped you in understanding indemnification provisions, analyzing the language, and tendering defenses. I hope that this will assist you early on when assessing the totality of the claim when confronted with indemnity claims. If you happen to run into any issues or something you need assistance with, please do not hesitate to call or email me so I can help. I firmly believe that part of my job at Secrest Wardle is to assist our claims teams. In the interim, we thank you for trusting us on our work, and we hope to continue this in the future. This is Matthew Consolo signing off. Thank you for attending.